Hello and welcome to the third module for LLB203 Constitutional Law in Week 4, which relates to the corporation's power. This first podcast in relation to the corporation's power is the fourth podcast overall for this week, and it asks the question, what is a foreign trading or financial corporation? And that's because this podcast and podcast 5 are concerned with section 5120, the corporation's power. Once again, by now you should hopefully have listened or watched the opening song, and then you will have listened to this podcast. You'll complete an online quiz which will involve an application of the activities test, which I will set out at the end of this podcast. You can then watch or listen to the fifth and final podcast for this week, which relates to the corporation's power and the scope of that power following the High Court's decision in Work Choices. There is then a little bit of reading, both in the textbook and from and relating to the Work Choices decision, and then a discussion question about work choices and the scope of the corporation's power today. But as I said, in these next two podcasts, we are looking at section 5120 and the corporation's power, which provides that the Parliament has power subject to this Constitution to make laws for the peace, order and good government of the Commonwealth with respect to foreign corporations and trading and financial corporations formed within the limits of the Commonwealth. So although we generally refer to section 5120 as the corporation's power, it is important to remember that it doesn't cover all corporations. It just covers foreign corporations as well as trading and financial corporations. So what this podcast is going to do is look at what we mean by those three different types of corporations: foreign corporations, trading corporations, and financial corporations. Foreign corporations is fairly straightforward. It's concerned with corporations that are formed outside the limits of the Commonwealth, namely corporations that are formed in another country but may well have some operations within Australia. They are considered foreign corporations, and the Commonwealth Parliament has the power to make laws with respect to those corporations under section 5120. What we mean by trading and financial corporations, though, are a little bit trickier. Starting with trading very briefly, once again we go back to that standard definition we get from Trade Practices Tribunal ex parte St George County Council, which provides that buying and selling are at the very heart of trading. And just to remember, or a reminder rather, from what we learned in the previous podcast, that the concept of trade that we see in section 51.1 refers to the same phenomena as in section 5120 as it does in section 92. So it's the same approach that we take across all of those references to trade in the Commonwealth Constitution. So what is meant by a trading corporation, therefore, is fairly straightforward. It really is looking at buying and selling. What is meant by a financial corporation, though, can sometimes be a little bit trickier. So some examples of financial corporations. We'll look at the case of Re-Ku-ring-gai Cooperative Building Society, and then the case of State Superannuation Board and Trade Practices Commission. In Re-Ku-ring-gai Cooperative Building Society, the issue was whether the Trade Practices Act of 1974 applied to the Ku-ring-gai and DY Cooperative Building Societies, which were set up to provide low-interest loans to their members for housing, but with only the ancillary objective of making a profit from providing the finance. So could you still consider them to be financial corporations if the idea of making a profit was only the ancillary objective? The court held that these building societies were financial corporations. They concluded that its predominant activity is the activity which it was formed to undertake: the borrowing of monies to lend to its members, the lending of those monies, the receipt of repayments, and the ultimate repayment of the monies to the source from which they came. These are money dealings. The activities of borrowing in order to lend and lending at interest are financial activities which give to each corporation the character and place it within the category of a financial corporation. So what we are particularly concerned with when we're looking at what is meant by a financial corporation is we're looking at these money dealings. Similarly, State Superannuation Board and Trade Practices Commission. In this case, the State Superannuation Board provided superannuation benefits to retired public servants, invested monies for financial gain, and loaned monies to members. And once again, the court held that this was a financial corporation. Note in particular the comments of Justices Mason, Murphy and Dean. Their honours held that the expression trading corporation are just like the words financial corporation in that they are not a term of art, nor do they have a special or settled legal meaning. They do no more than describe a corporation which engages in financial activities, or is perhaps intended to do so. A financial corporation deals in finance for commercial purposes, whether by way of making loans, entering into hire purchase agreements, or providing credit in other forms, and this activity is not undertaken for the purpose of carrying on some other business. However, just as a corporation may be a trading corporation notwithstanding that its trading activities are entered into in the course of carrying on some primary or dominant undertaking, so also with a corporation that engages in financial activities in the course of carrying on its primary or dominant undertaking. Thus, a corporation which is formed by an employer to provide superannuation benefits for employees and those of associated employers may nevertheless be a financial corporation if it engages in financial activities in order to provide or augment the superannuation benefits. So again, when we're talking about a financial corporation, we're talking about a corporation that engages in trading activities. Okay. These cases indicate that the court currently prefers the activities test in working out whether a corporation is a trading or financial corporation. But that has not always been the case. Historically, they used the purpose test, which asked for what was the reason or purpose that the corporation was established. And so in Trade Practices Tribunal ex parte St George County Council, the court held that St George County Council, which bought and sold electricity and electrical appliances, was not a trading corporation but a public utility that was supplying goods and services to the public. That was the reason or purpose for which the corporation was established. However, as you will have, as I have indicated, probably ascertained from those previous cases, the purpose test is no longer preferred. Instead, the court now adopts the activities test, which asks what are the current activities of the corporation, and you use that to work out whether it is a trading or financial corporation. And this came from Adamson's case. In Adamson's case, there was a football association that was engaged in promoting sport, charging transfer fees for the movement of players and charging entrance fees for matches. Now, ultimately, the court held that this football association was a trading corporation, with the majority applying the current activities test approach. What is somewhat tricky in the application of the activities test is what proportion of activities have to be trading and or financial activities in order for it to be considered a trading and or a financial corporation. And in Adamson's case, there were three slightly different formulations as to what proportion of activities have to be considered trading and or financial activities. So Chief Justice Barwick said that a corporation is a trading corporation if its trading activities are a substantial function of the corporation. Now, Justice Mason, with whom Justice Jacobs agreed, said that a corporation is a trading corporation if its trading activities are not so slight as to be incidental to some other activity. And indeed, in Obiter, they suggested that schools, churches, and charitable organisations are not trading corporations as their fundraising activities are not significant as a proportion of the overall activities of those bodies. And that Obiter will be relevant later on. The third formulation as to what proportion of activities have to be trading or financial activities came from Justice Murphy, who said that a trading corporation is a trading corporation if its trading activities are not insubstantial. Now, to be honest, it's not really clear to me what is the difference between Chief Justice Barwick's formulation, where you're looking at a substantial function, whereas compared to Justice Murphy's functions, which are a not insubstantial function, but nonetheless, those are the tests that the court set out in Adamson's case. This same test has been held to extend not just to trading corporations, but also to financial corporations, and this was confirmed in State Superannuation Board and the Trade Practices Commission, where in that case the majority stated that a corporation which engages in financial activities to facilitate its primary function is still a financial corporation. A corporation which engages in trading or financial activities does not cease to engage in those functions because they are entered into in the course of or for the purpose of carrying on a primary or dominant undertaking not described by reference to trade. So again, we're not concerned with the purpose, we're looking at the activities of that corporation. There are, however, sometimes corporations that have no current activities. And in that situation, the purpose, or sometimes formulated as the proposed activities test, should be used. And so an example of this comes from Fencott and Muller. The issue there was whether the Trade Practices Act extended to regulate Oakland Nominees Proprietary Limited, a shelf company. This was a company which had been incorporated and placed on a shelf. It had not yet engaged in any trading or financial activities. The court held that a shelf company with objects and purposes appropriate to a trading or financial corporation was a trading or financial corporation, even though it had not engaged in any trading or financial activities. In working out then what the purpose or the proposed activities of these corporations are, the court said you had to look at the constitution of the corporation to determine its purpose. At page 601, 602, the court said that in case such as the present, where a corporation has not begun or has barely begun to carry on business, its constitution, including its objects, assumes particular significance as a guide. Oakland's memorandum and articles of association revealed that the objects for which it was established include engaging in financial activities and carrying on a large variety of businesses, though it lay dormant on the shelf after its incorporation. In the circumstances of the present case, there is no better guide to its character than its constitution, and its constitution establishes its character as a trading or financial corporation. It is immaterial whether it is a trading corporation or a financial corporation, or which of those characters its future activities may give it. So, that then is the current approach. You apply the activities test to work out whether it is a trading or a financial corporation, but if the corporation has no current activities, the purpose or the proposed activities test should be used. The High Court once again considered this question in 2015 in Communications, Electrical, Electronic Energy, Information, Postal, Plumbing and Allied Services Union of Australia and Queensland Rail. Now this case arose from industrial disputes between the entity known as Queensland Rail and various trade unions who represent the employees of Queensland Rail. The parties were in dispute about whether Queensland Rail and its employees were covered by the Fair Work Act of 2009, a piece of Commonwealth legislation, and the industrial relations made under it, or whether it was covered by state legislation. That depended upon whether Queensland Rail was a trading corporation within the meaning of Section 5120 of the Constitution. Now, for this to make sense, we have to understand a little bit about Queensland Rail itself. Now, Queensland Rail is an entity established by the Queensland Rail Transit Authority Act. This act confers on Queensland Rail all the powers of an individual, including the power to enter into contracts, acquire, hold, dispose of and deal with property, and employ staff. The Act also provides that Queensland Rail may sue and be sued in the name it is given. Thus, Queensland Rail is an artificial legal person that has most or all of the features of a corporation, as that term is usually understood. However, Section 6.2 of that State Act declares that Queensland Rail is not a body corporate. Further, Queensland Rail has no shareholders or members, only a board and employees. Thus, to the extent that Queensland Rail is a corporation, it is a corporation without corporators. This type of entity, now quite common, is relatively new and was not known to the common law world at the time of federation. So the court had a few different questions to consider. First of all, whether Queensland Rail was a corporation within the meaning of Section 5120 of the Constitution. Second, if it is a corporation, whether Queensland Rail is a trading corporation within the meaning of Section 5120, and if Queensland Rail is a trading corporation, does the Fair Work Act apply to Queensland Rail and its employees by the operation of Section 109 of the Constitution to the exclusion of the Queensland Rail Transit Authority Act or the Industrial Relations Act 1999 of Queensland, or both? Also in this case, the court was given the opportunity to depart from the current activities test that we saw set out in Adamson's case. Several of the interveners, particularly the Attorney General for Victoria, had urged the court to depart from this test. That said, the Commonwealth Attorney General submitted that the court should not reopen or narrow the application of the established current activities test. So, in relation to the three questions that were before the court, first, whether Queensland Rail is a corporation. Now, the court decided that they did not need to answer this question, and instead moved on to the second question, concluding that Queensland Rail is indeed a trading corporation. Now, the joint judgment emphasises that the subject matter of Section 5120 is not corporations, it is foreign corporations and trading or financial corporations formed within the limits of the Commonwealth. The word corporations, therefore, needs to be construed in the context in which it appears in the Constitution. As such, the majority decided, or the court decided, it was unnecessary to state exhaustively the defining characteristics of a corporation in order to decide whether Queensland Rail is a trading corporation. Because, as the court concluded, by any measure, Queensland Rail has the full character of a corporation. So ultimately, the court unanimously held that Queensland Rail is a trading corporation within Section 5120 of the Constitution, and as such was covered by the Fair Work Act, thereby addressing those three questions that were for consideration by the court. There are a few important conclusions we can take away from this judgment. The first is that Section 5120 should not be interpreted narrowly to accord with a historical concept of what constitutes a corporation. And you see this in the plurality opinion of paragraph 22, as well as in the concurring opinion of Justice Gallagher at paragraph 65. They also concluded that a state parliament cannot determine the limits of federal legislative power. That is to say, the Parliament of Queensland was not, by virtue of the Section 6.2 of the Queensland Rail Transit Authority Act, able to, in effect, exclude the operation of federal law. And that, thirdly, there was no need to depart from the established current activities test for identifying a trading or financial corporation. And again, you can see this in the plurality opinion at paragraphs 39 to 43, and in the concurring opinion of Justice Gallagher at paragraph 70. Indeed, what we can take away from this case is that the current activities test is still the preferred test that the High Court uses to work out what exactly is a foreign trading or financial corporation. I would now encourage you to complete the online quiz whereby you will apply the activities test to a few real-world scenarios to get an understanding of the application of this test. Once you have completed the online quiz, you can then come back and listen to the fifth and final podcast for this week, which is looking at the scope of the corporation's power in Section 5120 of the Constitution.